Next on the docket are two cases. First, Greater Driftwood Estates, etc. versus Walton County. The second, Abbott, etc. versus Walton County. Mr. Masterson, I see you represent the appellants in both, and we're having a joint oral argument, so you may proceed.
Thank you, Your Honor. I'd like to reserve 5 minutes. My name is Steve Masterson. I'm here with my partner, Lane Smith. We represent the appellants, Driftwood Estates Homeowners Association, and the 5 individually named appellants. There are 4 issues on appeal. I'm going to focus on the first issue, which is the gravamen of this entire dispute, which is the abandonment of a roadway known as Driftwood Estates, or Driftwood Drive. The Supreme Court has stated, in a case I've cited in the brief, Board of County Commissioners of Brevard County versus Snyder, that since a property owner's right to own and use his property is constitutionally protected, review of any governmental action denying or abridging that right is subject to close judicial scrutiny. Each of my clients obtained their property through conveyance under the Driftwood Estates plat, which depicts as a primary access Driftwood Drive. Further, they purchased within the Driftwood or the Sandestin DRI, which designates and continues to this day on all maps on file with the state to designate Driftwood Drive as a 60-foot collector road, the primary access from their property to Highway 98, the main access. In 1988, the developer, through their vice president, Tom Patton, appeared before the county commission on February the 23rd and verbally stated, and the minutes are clear, Mr. Patton stated that he would like the Board of County Commissioners to advertise to abandon Driftwood Drive, a 60-foot right-of-way, and in that, the minutes, it was simply designated as Driftwood Drive, 60-foot right-of-way lying west of Lot 1, Block A, Driftwood Estates.
Counsel, does Section 336.10 Florida statutes require that the county record a petition to abandon a road before a resolution abandoning that road is adopted?
That provision, the 336.9 and 10 make it very clear, and this court has made it very clear in previous decisions that I've cited in the brief, that in 336.9, Section 1, it says, upon petition of any person. And in 336.10, it states that the petition shall be in writing and shall be spread upon the minutes of the commissioners. It's plain and clear language. And in this court, in the Webb case, found that a petition that was filed after consideration, that the proceedings were invalid and that the measure was void. And the cases repeatedly say that in the absence of a written petition, how can the people whose property rights are in jeopardy know what is in danger? And in this case, it's important to understand what happened.
Counsel, regarding spread upon the minutes, is there any case or statute or other authority indicating what it means to sufficiently spread a petition upon the minutes pursuant to Section 336.10?
I think I haven't found a case that explains what spread upon the minutes is. What I have, I think the plain language is, if you don't have the petition in the minutes meaningfully so people can review, and as this court has required that those minutes or that petition be available for the people whose property rights are in danger, there is no adequate notice. So the failure to in any way at the time of that February 23rd meeting to have a written petition that would put people on notice of what was in jeopardy. And in this case, this court...
Does the record... I've got some concern about the state of the record, but was the petition here recorded in Walton County Public Records?
It was on the 21st of June of 1988, which was 41 or 42 days after the action taken by the county commission. Now, this court, and I believe it was the Webb case, found that a petition that was filed 4 or 5 days after action taken rendered that action invalid. So the record is absolutely clear here. The county would like this Court to believe that Mr. Patton gave an affidavit that there was a petition filed sometime contemporaneous with the February 23rd meeting. But the records of Walton County are clear, and it's instructive that each of the 3 board meetings that at issue here never refer to any writing until May the 10th, when they refer to an agreement in indemnity, which that written document wasn't filed until the 24th of May, 2 weeks after the action taken. So never was there anything in writing, as this Court has repeatedly, not repeatedly, but at least on 2 occasions said, notice requires that the petition or the resolution be available for inspection by those whose property rights are in jeopardy.
Regarding your publication of the petition argument, where in Section 336.10 does the legislature require the county to publish a petition for public inspection before the county can enact a resolution?
Well, the action that institutes the abandonment proceeding is the presentation in writing and spread upon the minutes the request of a person or persons. That never happened before the action that was taken by any record in this, any record that's ever been produced. The record is clear. The only petition was filed on the 21st of June. The only resolution and the indemnity agreement was filed on the 24th of May. And there's another aspect which can't be escaped in this case. There's no doubt in 336.10 that you have to have notice. And certainly there was notice. Now the problem is that Mr. Patton shows up on the 23rd and gives an ambiguous description, as this Court has noted in the Walton case, where there were 3 different descriptions which rendered that abandonment void. But what happened is that Mr. Patton says, I'd like to abandon this piece of roadway. Then there's a notice published on the 3rd and the 10th of March. And then there's a meeting on March the 29th, the only advertised meeting. And the Schneider case and the Bula case both talk about the fact that you don't get, these are quasi-judicial proceedings. You don't get to just say we're going to have a hearing and then not have it. On the 29th of March, Mr. Patton got up and now, in complete contravention to the notice that was published, says, we're not trying to deny anybody. We're going to give them a 20-foot right-of-way, a 20-foot easement, all the people that are entitled to it. Mr. Green, I think it was Mr. Green, but the lawyer who had appeared at that meeting on behalf of the homeowners said that's not acceptable and this should be tabled till we can work this out. And what does the county commission do at that time? They say unanimously that they pass a resolution to table the issue until all concerned parties have reached an acceptable agreement. All concerned parties.
But, Counsel, regarding issue 2, the individual public did not acquire their property until several years after the county abandoned the easement. Is that correct?
That's correct.
Yeah. Are there any exceptions to the rule articulated by this Court in Lopa versus City of San Agustin Beach that a resident challenging the enactment of a zoning ordinance is not entitled to notice if he or she was not a resident of the affected property at the time of the enactment?
What case are you citing?
Lopa, that's B-H, I'm not sure I pronounced it right.
I've been calling it Bula.
B-H-O-O-L-A versus City of San Agustin, cited at 588 Southern 2nd, 666. It's a 1991.
Your Honor, with all due respect, I think you're misreading Bula. What Bula says is there is no requirement in Raynard that the challenging party must have been a resident, citizen, or owner at the time of the purported enactment. The attempt to enforce a void ordinance extends its evil far beyond its original purpose, purported enactment. A late arriving owner is no less affected by the enforcement of a void, non-existent ordinance than had he been present a lifetime. He is being denied the right to use his property in a way permitted by all legal city residents. He has standing. And it then distinguishes Driggs. This Court, that's a 5th DCA case, this Court cited Bula in the Webb case, affirmed, and the Supreme Court has cited Bula. Driggs is an anomaly in our law, but Bula is very clear that a void ordinance cannot stand to deny a property owner. Mr. Osborne, for instance, took his property in 2005 and discovered that he had no real access, and then discovered that he'd acquired a right to a public road under the DRI and under the Driftwood Estates plat, and was...
Didn't this court in Mbola, if I pronounced that correctly, clarify that the appellant was not entitled to notice because he was not a resident at the time of the enactment?
No, what it said is that that isn't the issue. The issue is that had people back then been given notice, which is what happened, the people who did get notice got up and said, no, we don't want a 20-foot easement. What we want is the right, well, they didn't really get a chance to say what they wanted, but the matter was tabled. But Bula says that those people could have stood in that place, but in the failure to do the enactment properly, to accomplish it properly, rendered the act void, and it's just as void to Mr. Osborne taking in 2005 as it was in 1988.
Well then, counsel, if we find that the county did not violate the notice requirements of Section 336.10 when it enacted the resolution abandoning the right-of-way, do you still have a standing to challenge the county's action?
Yes.
Why?
Because they didn't have a hearing. You have to have notice. What if I had summary judgment below? And I've actually seen this happen once where a court would give you a hearing date. But I show up with the hearing date and I don't have a motion for summary judgment, violating all the rules. And the judge says, gee, come back in 40 days when you've got a motion and we'll deal with this. And then I come back in 40 days and I don't tell the other side I'm going to be there. That's what happened here. Everybody showed up on the 29th of March and they said, we don't like what you're trying to do. We want to oppose this. So they said, we'll fix that. We'll have another meeting with no notice to anybody. We'll enter into an agreement of indemnity, which on its face says was on the 4th of May, and approve that on the 10th of May with no notice. And when you read all that put together, you not only don't have a hearing, but what you have is something that doesn't conform to any prior notice. The final indemnity agreement and resolution doesn't say there's a total and complete abandonment. It says that what we're doing is not denying anybody who has the legal right access to their property. Now, what does that mean? And what notice would that have given, even if anybody had been given notice, to tell them what that was doing to their property rights? I think I've overstepped my...
You're down to about 3 minutes.
Yes, sir. Thank you very much.
May it please the Court. My name is Greg Stewart of the law firm of Neighbors Giblin Nickerson, representing Walton County. If I could be notified when I have 3 minutes remaining so I can leave some time for Ms. Ankers to address the issue related to her client. As the Court indicated, these are consolidated oral arguments. The same issue is, the primary issue is the same in both cases, and that deals with the abandonment back in 1988. Now, we've had some discussion in appellant's argument concerning Driftwood Drive and what is it, and it's a collector road. The record reflects that what we're talking about here is 60-foot right-of-way that connected Driftwood Drive to a road called Sandestin Loop Road. And that particular road has never been improved. That road, in fact, has been nothing but a jeep trail or goat trail. Now, and in fact, since the mid-90s, there has either been a wall or a fence which has completely blocked off any access through that way. Now, we believe that... Was this wall or fence installed prior to the individual appellants acquired their property? It was installed prior to them acquiring the property. It was a fence from the early 90s. It was substituted with a concrete wall in 97, I believe the record reflects. And the owners generally acquired their property after 2000.
So the access from the development to, I guess it's US 98,
Yes.
is through Harborview Road. What's the access?
Well, I may have my roads, but Driftwood Drive is a triangle piece of property, which is the Driftwood area.
Right.
And Driftwood Drive circles that and then extended on and joined a road called Shipwreck Road. And I think it's Mac Bayou Road that takes you out to 98. It may change names, but that is the access that was in existence back in 1988. That is the access that is there today. That is the way that traffic gets to 98.
So on the Exhibit 2 to your answer brief, that particular map, the area to the south of the development is not bounded by US 98, but this, what you say, described as a Jeep Pass Sandestin Loop Road?
Correct. It was just a trail. It was a goat trail that had never been improved. It was just right away on the plat itself. Now, I think that one of the big issues that we had a lot of argument concerning was what exactly was filed, what does spread across the minutes mean? The record before Judge Laporte.
What does spread across the minutes mean, counsel?
My reading of that, if you read, there's two aspects in terms of recording in the public record. The first one, dealing with the petition, talks about spreading across the minutes, and that's in 33610. Where that was accomplished was at the meeting of February 23rd, when Mr. Patton, having filed already a petition, and his affidavit states, in early 1988, I signed and filed a petition to Walton County on behalf of Sandestin Bay Estates, Inc., to abandon a small portion of Driftwood Drive right away. Now, at that point in time, the minutes reflect that there is a petition or an effort to abandon that road, and at that point, the Board of County Commissioners authorized the publication for a public hearing to take public comment. So I believe that that first February meeting and spreading across the minutes, that is what is satisfied by that. There is a second component after everything is done that requires a recording, and that also was accomplished. The petition, the resolution, the agreement, all of the notices were all recorded in the public record and continue to be in the public record of Walton County today.
Well then, counsel, do the notice requirements in section 336.10 apply to every hearing before the board? And the second question, was the county required to publish notice for the May 10th, 1988 hearing?
Not all action, well, as to the first part, your first question, county commission meetings are all public meetings. They all must be notified. Actions may be taken by resolution by the Board of County Commissioners that do not require a specific published notice. Because this was an abandonment, there is a requirement that the county had to publish notice of the public hearing more than 2 weeks prior to the hearing. The county did it twice. They published it on March 3rd and again on March 10th. For the March 29th meeting. So there is a little bit of a difference in terms of the notice that is required under an abandonment context as opposed to perhaps another resolution to support the Girl Scouts or whatever the Board of County Commissioners was approving.
And Counsel, wasn't there also a requirement that the petition be in writing?
It is in writing, and it was writing, and Mr. Patton's affidavit said that it was. He filed it with the Board of County Commissioners in early 1988.
Counsel, again, the second part of my question.
Yeah.
Was the county required to publish notice for the May 10th, 1988?
I do not believe they were. And the reason why is twofold. First of all, the board did publish notice of its March 29th meeting, and the purpose of that was to take public comment. That public comment was taken. With all due respect to appellate counsel, that there was no meeting. There was a meeting. The minutes very clearly reflect that it was a spirited meeting, that there were part of the public objected, they were concerned, and at that point in time, the county commission indicated that they would like the parties to try to work it out. And they tabled the matter. Now, unfortunately, because this came up 18 years later, we don't have the tape recordings of those meetings anymore. So we don't know whether, in fact, there was a continuance to a time certain at that meeting. But I still don't believe that any specific notice was required because the county did give notice. The county also took the public comment, and that is all that was required by 33610. Additionally, once the resolution was adopted at the May 10th meeting, the statute requires that a notice of abandonment be published, and that notice was published. So, and within 30 days, anyone who objected, anyone who wished to contest that had a point of access at that point. So even if there was a requirement that they had to go through all of the process again, I believe the subsequent publication would cure any deficiency there. Personally, I think they took the public comment. I think that's all that was required by law. Now, I think that if you look at the requirements, it appears that all of the requirements of the statutes were complied with. Notices were given, public input was provided. This meeting of May 10th was not held in a dark alley. This was a regularly scheduled Board of County Commission meeting, which is noticed. The public is free to attend. The only difference was a specific published notice was not again made, because that had already been done. Now, the issue, Judge Lewis, that you had raised was, let's talk about standing and I believe the Bula. The operative fact in Bula states the general rule, which is that the only parties that have standing to contest notice are those that have an interest, have a right to notice. Bula was a little bit different because Bula, there was no notice. And there had been no attempt to provide any notice, and so the court there said, that is the general rule, that if there's notice given, nobody can contest and question it unless they had a right to receive that notice. Bula basically said, because there was no notice or any effort to even comply with anything, we're not going to penalize those people. That's not what we have here. We have notice. We have 2 publications where 1 is required. We have 2 public hearings. We have recording in the minutes. We have a published post-adoption resolution in the newspapers that give the public notice that this abandonment has occurred. And that's the same thing with the Webb versus Hilliard. In that particular case, it also states the rule, but there was a verbal request to rezone property, and it was done at that meeting based on a verbal request, which was contrary to the statute for rezonings.
Counsel, if we assume, for the sake of argument, that the county did not comply with the notice requirements of Section 336.10, would appellants have standing?
No, I do not believe they'd have standing anyway.
Why?
Because they did not have an interest in the property. And we cite Section 125.66 per 5, which sets the general rule that says that a party that did not have an interest at the time the notice was given has no standing to contest that notice. So we believe the county complied completely with 336.9 and 336.10. But even if they didn't, they would not have standing. The plaintiffs in this case came to this case 15 years later, 15 years after this was done. They clearly had no right to notice at that time. They had no interest in the property at that point. And I believe Mr. Masterson's point is one we had made with the trial court, is that the remedy in this matter is a petition for certiorari. This is a quasi-judicial proceeding. And the remedy was in 1988 was to file a petition for certiorari if there was anyone who objected to it. No one did.
Counsel, regarding the special injury requirement for standing, our courts have found that a party sufficiently proves a special injury for standing purposes where that party's quality of access to their property has been diminished. By forcing appellants to enter only by the Highway 98 and Mark Bale Road entrance, haven't the county diminished appellants' quality of access to the property?
No, sir. The access that they had when they bought the property is identical to the access they have today. There was a brick wall, a stone wall, over this supposed access that was there when the plaintiffs purchased their property. The Homeowners Association itself was not even organized till 1996. At that point, there was a fence across that. The access that they have continues to be the same access that they had in 1998 and they have today. There has absolutely been no diminishment of their access. One point I would like to touch on that was raised in the 09-975 case, which is the breach of contract. And Judge Laporte also granted summary judgment on that issue. And the issue there was at the May 10th meeting, there was an approval of an agreement. And that agreement was between the developer and the county. and did two things. It indemnified the county from claims for the abandonment, and it required that the developer would assure that properties would have access. And the undisputed evidence and matters presented as part of the record showed that all of these properties had access, that was provided, and therefore summary judgment was appropriate because there was no breach, even assuming they were third-party beneficiaries.
Is the county even the proper party to assert this contract claim against?
No, that is our second point, is that the obligation to provide access was not the county's obligation. It was the developers. And even if they were a third-party beneficiary and they sought to enforce rights under that contract, their rights are against the developer, not the county. We believe that, we will stand on our brief concerning the issue of the striking of the jury trial. Clearly, the trial court did not strike any right to a jury trial on the breach of contract claim. It only dealt with the issue of abandonment, which was a statutorily created right and not based in common law. We would ask that the court affirm the summary final judgments entered by the court in both cases. And I'd turn this over to Ms. Ankers for her issues.
May it please the Court. My name is Michelle Ankers, and I represent the Sandestin Owners Association. We do support the position of the county. We also ask that this Court affirm the order below. My issue that I am here for you on was not addressed by the Appellant's Counsel, so I don't want to belabor it. It's a procedural issue, but I will briefly address it. The circumstances that brought us here are that the appellants, the plaintiffs below, a homeowners association itself, and some individual owners filed a complaint. Sandestin moved to dismiss. The court granted that move to dismiss and gave the party 20 days to amend. 8 months later, they had never amended. 8 months after the court entered its order to dismiss and amend, they had never amended. So Sandestin looks at its options in order to bring closure and to give the court some control over its caseload and manage the judicial economy. The court took upon its own the Sandestin's motion for final judgment, and the court granted that motion for final judgment. The only thing that court could do, the plaintiffs would ask, and the appellants in this action would ask, that you just have the court do the same thing it did before, which is enter another order to dismiss and give them more time. And that certainly doesn't make sense from any point of view. The Neslick versus Sunbeam case, I think, presents a roadmap both to practitioners and to this court as to how an issue like this should be addressed.
What's the correspondence between counsel indicating they did not intend to amend the complaint?
Your Honor, that correspondence is not in the record. I was not trial counsel. I'm appellate counsel, and I can say that I've never seen that correspondence.
And that correspondence is not a part of the record?
That's correct, sir. So once the court has dismissed a complaint for failure to state a cause of action but has granted leave to amend, the complaint may be dismissed under Neslick if separate notice of hearing on the motion for entry of final judgment is given, and it was given in this case. The appellant had the opportunity to respond to the motion for final judgment. The court heard it. They got notice. That's all that's required under the rules of civil procedure. For those reasons, we ask that you affirm the order. Thank you.
On that, the point just addressed by Ms. Ankers, we'll just stand on our brief. I prefer to devote our time to the abandonment issue. Mr. Stewart talks about the quality of this road, Jeep trail, goat trail, whatever it is. None of that's in the record. But what's more important is nobody has the right to diminish my property rights, whatever you want to call them, without due process. You can denigrate them, as has been done here, and say, oh, it was a Jeep trail. No. The DRI designated as the collector road, a 60-foot right-of-way giving these people access through the DRI, not through property that was not on the DRI, Harbor View and Mac Bayou, roads that flood. And then as far as the spirited hearing, this court, in the Bolden case, spent a good bit of time talking about the hearing isn't some sort of pro forma little meeting that you just accomplish to meet the facial requirements of the statute. It says that they've got to have a fair hearing. You can't cut people off. You can put time restraints, but you got to give everybody a chance to be heard. Now, the spirited meeting that occurred on March the 29th occurred after Mr. Patton gets up and says, gee, we're going to give these folks a 20-foot easement. And Mr. Green got up and said, for the residents in Driftwood Estates, asked the board to take no action on the abandonment. No action on the abandonment drive until differences have been resolved. Motion by Commissioner Miles, etc., to table the issue until all concerned parties have reached an acceptable agreement. And Judge Lewis, the idea that you can do that and not give notice for the next hearing is this is a quasi-judicial proceeding. Can I do that in my court cases? Due process is the same there. I mean, when the judge says, why don't you fellas go out and try to work this out amongst yourselves, and I've had that over my 30-some years. I've been around just about as long as Judge Van Nortwick. The judge needs to go out and try to work things out, but not come back, one of you, and decide what the court ought to do at that point. We all have to come back under the concepts of due process. What happened was the county commission and the developer got together, struck a formal agreement, and had a meeting with no notice to anybody, with no hearing, because the minutes of that meeting, which are in the record, say that they simply heard Mr. Patton say, let's do this, and I'm not trying to deny anybody their rights to access. Gone from the entire consideration by the county is what's in the indemnity agreement and Mr. Patton's assurances that people with the right to access would not be denied that access. Instead, they built a wall. The Bula case isn't about notice. It's about when you do not follow the statute is void. Not voidable, it never happened. As Bula says, it never existed. And thus, if you're enforcing the diminution of my property rights with a void statute, it isn't a matter of standing 18 years ago. It's a matter of standing today. You can't do that.
But didn't, in Bula, weren't the facts different? Wasn't there no notice, basically?
Well, in this case, we argue there's no notice of May 10. We also argue that as this case is laid out in Walton, you've got to have consistency as to what is going to happen. And what we have here is no consistency. What we have is one thing being said on the 23rd of February, another thing being said on March the 29th, another thing being said in the indemnity agreement that was privately struck between the county, and then not much being said on May the 10th. And this court talks about a full and complete hearing with substantial evidence to support the public purpose of the resolution. That never happened. And finally, the appellees would like you to believe that Mr. Patton, because he says he did it, filed the petition when he talked to the county commission on February the 23rd. The clerk of the court stamped in that petition on June the 21st of 1988. 40, depending on whether you count 10th, 41 or 42 days after they considered the abandonment. That's the record. Mr. Patton can say whatever he wants, but this was a summary judgment, folks. Excuse me, Your Honors. This was a summary judgment. So that, amongst many, many aspects of this case, were certainly in dispute. Mr. Patton's assurance that he did something, as opposed to the formal record before the court, that it didn't happen until 42 days after the action taken.
Counsel, your time has expired.
Thank you very much.